Do you know what a high-low agreement is in a medical malpractice case or an accident or even a wrongful death case here in the state of New York? Would you like to learn? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. A high-low agreement involves a potential settlement and involves the negotiation process leading up to a possible settlement. And here's what I mean. The parties cannot reach a definite agreement as to how much the case is worth. So now they'll say, you know what? How about if we reach an agreement where we say, listen, there's a range of value here for this particular case. There's a low range and there's also a high range. So let's do this. Let's take the case all the way to trial. Let the jury decide how much this case is worth. And if the jury decides this case is worth this much, let's put a cap, let's put a ceiling on the amount of money that we think the case is worth. And on the other hand, if the jury awards you nothing, let's put a minimum amount that you're going to get if the jury decides that you're not entitled to anything. So this way, there's a trade-off. The trade-off is that if the jury decides that you're not entitled to anything, you will still get a minimum amount that is agreed upon before the trial. And on the other hand, if the jury comes back with a very significant award, it means that the defense will only have to pay a maximum amount, which is the high amount that you agree on prior to trial. So that's known as a high-low agreement. And importantly, as you go to trial, if you have reached that type of agreement, it is critical to let the judge know that information before you begin the trial, or if you reach that decision during the course of the trial. So now you've come to the decision, listen, we can't reach an agreement, we're going to let the jury make a decision, and then based upon their particular decision, that will determine how much you're going to be awarded no matter what their decision is. By the way, what happens if the jury comes back with a decision, makes an award for you, but that award is between the high amount and the low amount you've agreed upon? In that instance, you will obtain what the jury has awarded. So that high-low agreement is simply to limit the maximum amount that the defense will pay out and to also minimize and in fact give you a certain minimum amount of money in the event the jury decides you're not entitled to anything. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process, in a medical malpractice matter, in an accident case, in a wrongful death matter here in the state of New York. You know, I recognize you watching this because you probably have questions of your own. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.